Okay, let's get into our next discussion. It is just 2 months to the 2019 elections, but there's no clear-cut guideline as to how the elections will be conducted as a result of the president's refusal to assent to the Electoral Act Amendment Bill.
President Buhari, for the fourth time last week, refused to give assent to the Electoral Act Amendment Bill 2018 passed by the National Assembly. The president's decision has been greeted by reactions from different quarters. The big question is, will the National Assembly override the president's veto on the rejected electoral bill? We have a constitutional lawyer, Ahmed Abbas, in the studio. Of course, he will be joining us later on. Dan Okoye is here with us. Good morning and thank you very much for coming.
You're welcome.
Glad to have you come. All right, so it's no longer a question of whether Mr. President has the prerogative to withdraw his assent to this bill. The question is, why has he returned it 4 times, given different reasons? Now, the latest one is the fact that there's just too short a time between now and the general election, and he doesn't want confusion as regards which law will guide the process. What are your thoughts as regards this?
Well, essentially, the president and his advisors are entitled to their opinion, but there appears to be a disconnect between the president and the National Assembly. Public money was expended on public hearing, and when the bill was returned the last time, the president pinpointed some sections which he considered to be offensive, like the reordering of elections and some other issues, which were removed. Still, he gave his reasons. His reasons are, well, he's entitled to his opinion as the president.
You think these reasons are not genuine?
Well, I won't say they're not genuine. It depends on the way you see it. The fact is that we have the guidelines. We have the 2015 amendment. And the problem with Nigerian elections have never been the issue of laws. Our laws may not be the best, but our problems stem from institutions. If we have an independent INEC, going by the provisions of the Constitution, which gives INEC the power to make rules for the election, INEC has said, with or without the amendment to the Electoral
They're ready to go.
they will not make use of the controversial incident forms. Now, there will be direct capture of fingerprints and then phone numbers.
But what they said precisely isn't that they won't use incident form. They said that unlike before, when incident form was a different document, it has now been incorporated into the broadsheet of the voter register, such that there is now a back end. There's a way you can trace it back precisely which of the voters, registered voters, used an incident form. Because there is no way you cannot use an incident form in a case where the card reader, as it were, is not known to law.
No, you won't call it incident form. This time around, the identity of the person will be captured.
Apparently.
Once you have the fingerprint and you have the phone number, it means that it's traceable to a particular person.
Right.
Not the case of the rumor had it that maybe there will be 500 incident forms for absentee voters. But why should that even be contemplated if the major political parties have agents at the
in all the polling units?
EU units? Such may not be possible. So, at the risk of repetition, I have gone through the proposed amendments. Some of them are very germane. The electronic register, appointments to INEC, that the individuals will depose to affidavit that they don't belong or have affiliation to political parties. But if it's found out, it becomes a criminal offense. These are all okay. These are very, very beautiful legislations. But it's equally surprising. The National Assembly, the Senate leader is still with the ruling party. And if they had wanted, even the executive, the amendment could have come by way of an executive bill. You tell them what you want. I see whether the National Assembly will go ahead to override the veto of the president. For me, may not be possible because it will be difficult
to get the numbers.
To get the numbers. So we have what we are working with, the 2015 Electoral Act.
All right, we have used this Electoral Act for the last election. So the question of whether Nigerians understand or don't understand may not necessarily be up right now. But going into the 2019 election in 2 months, the president's main reason now for this fourth withdrawal of his assent is the issue of the timing. He's saying it's too close to election, and Nigerians are going to be confused as to which of the laws are we acting by and all of that. Now, how strong is that point when it comes to the issue of Nigerians are going to be confused? Because the implementer of these laws, as the case may be, is INEC, with the knowledge of all the political parties. How strong is that point?
Well, as I said earlier, he has his advisors. Personally, I don't see it as being very cogent. Even though he's very much, as the president of the country, he's very much entitled to his opinion, and we are left with no choice. Essentially, the last amendment came into effect in 2015, few months to the election, and it was used. And it's not an entirely new legislation. Some specific sections were targeted. And the essence of targeting them was essentially to make our electoral process better. But taking it the other way, I believe that with what we have, elections can still be credible if Nigerians generally, not just INEC, want the election to be credible.
The proponents of the amendment bill, what they want is the introduction of technology in the process of our election. They want a situation where election results can be electronically transmitted right from the polling unit, right after. Even they're talking about full biometric accreditation and all of that. Now, the challenge of that is, do you think that we are ready, within the short period of time, to be able to go full digital without providing manual alternative for a big election?
Essentially, it's obvious that we may not be ready for that. That's the bitter truth. And whether we go fully biometric or not, it may not necessarily affect the credibility of the election. We tried digital, electronic, internet voting with the NBA elections, and we are still in court. So the fact that an election is digitalized will not necessarily make it to be credible.
And it's also very pivotal to understand the point of view of Mr. President at such a time like this, when they're talking about international commitment, international conventions, which Nigeria is signatory to, which of course requires that the Electoral Act of any country shouldn't be tampered with 6 months before an election. And it's just less than 3 months to a main election. But folks are saying that these signatory or all these international conventions are not laws in Nigeria. Help us understand the dynamics of
the interplay.
whether this is binding on Nigeria as we speak?
Well, international conventions are not binding until it is fully domesticated and it's not been done.
Via the National Assembly.
Via the National Assembly. So it's not been done. And then we have our democracy is peculiar to us. We hear terms that are not very common elsewhere. Vote buying, vote snatching. These are things we have to deal with internally. So if the president had assented to the bill, there will have been nothing wrong. There will be no sanctions. It means that that's what Nigerians want. The National Assembly is also a representative of the people.
All right, Nigerians, on the other hand, analyzing the president's withdrawal of his assent, liken it to throwing away the baby with the bathwater, because they're saying that the point there is, it's not even just about this election. It's about strengthening the electoral process as a whole, because this is not the only election we're going to hold. There's still going to be election in 2023. There's still going to be other elections, staggered elections here and there. So even if it's not the issue of the legal part of things, even the moral part of things, the political part of things, the democratic part of things, the president should have seen the bigger picture.
No, you can't take it away from him. In returning the bill, he did that under Section 58, subsection 4 of the Constitution, and the major reason being that it should not be applicable in 2019 elections. So if the 2019 elections, so if the bill is represented with the 4 minor amendments and 2019 elections excluded, it's obvious that he will assent to the bill.
That's all right. Let's take this conversation outside the studio. Joining us on phone now is the former Attorney General of Nasarawa State, Innocent Lage. Thank you very much for finding time to join us. Now, what is wrong, in your opinion, with the substantive electoral law? The 2015 election is widely adjudged to have been a main improvement on previous elections in Nigeria. Do you think that this document can still serve us better and even improve the electoral process in 2019?
Yes. Yes, I think so. Let's go back to what the Supreme Court had said about the card reader as a means of accreditation. Some of the process that INEC used in the 2015 election tentatively were overruled by the High Court. By the Supreme Court of Nigeria. For example, we couldn't use electronic means to conduct that election. So the amendment that was made to the Electoral Act seeks to stay in line, to give meaning to what the judiciary really wanted. What the legislature really wanted when they amended the Act. But let me say this and say it quickly. It is the principle of the Nigerian law that laws do not work in retrospect. So if the president had signed this law, it will take effect from the date that he appends his signature on. So everything INEC had done previously will not be affected by it. Anything that cannot be done within the time the Constitution provides for the days within which to have an election will have to be in the next election.
But help us understand the position of the Supreme Court precisely. If the Supreme Court doesn't recognize the use of electronics, how come we use the card readers in 2015? How come INEC is also saying that it has improved upon the card readers for use in 2019?
Exactly the point we need to make. I was listening to the wreck of Akwa Ibom State yesterday. And for anybody who listens to that and understands the law knows that we're in trouble in the next coming elections. The process of accreditation is the fundamentals for any elections. Now, if you are saying, I will verify the card before I conduct the election. These are plastic cards, different from when we used to have paper cards, that when you are going to conduct an election, an electoral officer will stamp on it and show that it has been used. In the last elections, we had situations where the card reader failed completely. So the card reader couldn't read the card, couldn't read the fingerprint. So how do you now be able to confirm when this election gets to be disputed in a court who voted and who didn't vote? So an improvement of the card reader, for example, as stated yesterday by a representative of INEC, was that they will bring two columns where where your fingerprint doesn't read on the machine. You will thumbprint it on the accreditation document. Now, if you do that, how then do you determine who that person votes for in a disputed election? Now, the only use of the card reader can only verify the card. It doesn't verify the person carrying the card. And we have no means of such verification. The last time we tried to use incident forms, the Supreme Court said those are not applicable. Now, we have a situation where, ignoring the provisions of the Constitution that the legislature make laws for the good governance of the country and cannot delegate legislative powers. And you see INEC insisting that the Constitution also gives them power to make regulations. I agree absolutely. But regulations are not laws. Now, some of INEC regulations were what we said, the Supreme Court said, you can't do that because it's not supported by law. And some of those decisions were upheld by INEC. Now, the beautiful thing about legislature is this. Everybody thought we could use the card reader for that elections. But then we found out that there was a problem with our laws in such a way that the courts are right to say, okay, look, your law does not provide specifically for the use of this card reader. What normally happens is the legislature will now, by virtue of that, amend the law to be in line with the decision of the court. Now we understand what we need to put in the Electoral Act to bring us to exercise the powers to use electronics in our elections. Now, but before we go far, let's understand that the amendment to this Electoral Act did not also start now. It has been sent to the president 3 times, and 3 times he has rejected it. Now, for anybody to argue that the amendment that is being sought to be made is to be able to disrupt this election, it's just not fair on the intelligent psyche of Nigeria. Now, laws do not also operate in retrospective. If you have finished the process of nomination, anything this law says about nomination that is outside the time within which the Constitution provides that such elections will be held cannot be asked to be enforceable against the Constitution.
All right. So, Innocent, the point there is there's another issue here. The president picked holes with the drafting. He had issues with the drafting of some of the use of some sentences and the use of some words in the draft as sent by the National Assembly were part of what the president said.
The president has no right, absolutely.
Okay.
Let's put it in perspective. Assuming the president has refused to sign this amendment as it is, and the National Assembly insists on vetoing the president on this bill as it is, it will become law. Now, the only arm of government that has the responsibility to give words and interpret words in a written law is the judiciary. It is not the president who will tell us what the law means. It is the judiciary who actually interprets the law and tell us how it is. Now, the issue is these are typographical errors that can be corrected before even the Gazette is made public.
Beyond typographical, let's take section 63, subsection 4, for instance, which which addresses the issue of counting of votes and forms. Now, this subsection says the presiding officer should count and announce the result at the polling units. Now, according to information we have, the amended version to this subsection strikes out count and simply states that the presiding officer should announce the result. Isn't that process liable to manipulation?
Look, we have what we call, there is a record of proceedings of every legislative house. So if there is a problem with the the print copy sent to the president as to what truly the National Assembly had passed, all you need to do is go back to the proceedings of this house and verify truly what had happened. The National Assembly do not type the final law. It is actually the clerk's office that does that. Now, we all know that this is the capital. Let's be honest about it. There's nobody who will act, no sane person will even think that we can announce results of an elections without counting them. Nobody. And no court will say no court will agree, even if it goes up for interpretation, that we can announce results of a process that has not gotten the process to be counted.
Okay.
So we're simplifying very simple issues. The president himself can just count and sign that bill into law.
All right. Let's leave it here now. Former Attorney General of Nasarawa State, Innocent Lagi, thank you very much for talking to us this morning on this issue. Thank you. All right, let's bring Dan back here as we round off. What scenario do you see going forward? Because the point there is 4 times the president has said no, citing different reasons. What do you see going forward?
Well, the picture is not very tidy. I know that Nigerians would like a situation where there will be better relationship between the executive and the legislature. Even though it's the duty of the judiciary to interpret. But if we are able to avoid ambiguity at the point of drafting an assent, then it's better for everybody. He has exercised his powers as the president. If the legislature can muzzle the numbers, they can go as well and pass the bill, which is very unlikely.
And veto the president, which is quite unlikely, like you said. All right, we have to leave it here now. Dan Okoye, thank you so much for coming on the program.
You are welcome.
Thank you.
Right. Good to have you.